Well, I think let's begin. I'm Bruce Barkhazen from Brunner Smart Attorneys. I've had extensive experience in drafting contracts, especially within the commercial sphere, especially with regards to facilitating certain transactions and obtaining certain outcomes. There's a bit of a difference, but we'll get to that in a bit. So from my view, there are certain steps. Well, we all know that there are certain requirements for contracts: capacity, formalities, legality, possibility, and certainty. Possibility and certainty is a favorite of mine when I'm litigating, in that if there's a shortcoming in possibility and certainty, for instance, the agreement is vague, I would attack that. Or the legality of the contract in question, I attack that. Or the formalities have not been adhered to, for instance, anti-nuptial contracts that weren't officially executed before a notary, I will attack that. So from a litigation perspective, these formalities and requirements need to be adhered to at all times for a valid contract. So that, in a nutshell, is just a recap of what we all learned at university. And then there's the drafting process, or at least my drafting process. Obviously begins with taking instructions and being acquainted with the applicable laws. For instance, if you're drafting a contract within the mining sphere, you'll want to be aware of certain clauses that can actually attribute liability to your client or help your client evade liability. Not in the criminal sense, but rather in the civil sense. Again, this speaks to knowing the laws, knowing what is applicable in your respective field, or applicable in the realm of where the contract fits. Think, for instance, a lease agreement in respect of farmlands. Now, this would sound innocuous enough. However, it is rather specialized if you don't know what you're actually doing. For instance, contours can't be moved. Moving of fences, especially boundary fences, is actually a criminal offense, believe it or not. And so forth and so forth. Soil management plans, also bearing in mind that certain crops prohibit the planting of other crops in the next season or following seasons. So knowing the law is vital for a good contract, especially, and also making sure you've got proper instructions. And then you go on to the drafting step, and there you use your language rather deliberately. Shall versus may, will, would, should. You're very careful with the language you use, as the language and even the tone sometimes, although I disagree with that view, the language and tone can actually shape the respective obligations upon the party to the contract. Obviously, as you engage in your client, there'll be multiple revisions of the agreement from time to time. There are certain practical steps that I take when dealing with revisions to clearly show what is a revision and what is not a revision. Last thing you want to do is work on an old contract and introduce new clauses in, and then you've got a bit of a mixed match that doesn't really help anybody. Then there's finalization and execution. There are also certain steps that I prefer to take. This limits the liability of a legal practitioner, as well as ensures that you have a signed copy on file, something which I'm very, very passionate about. But anyway, let's dive right in. And also, the other presenters are more than welcome to chime in. I'm not the only contract drafter on the planet Earth. So, instructions, most important, almost vital, is understanding the transaction. If you do not understand the transaction, you will have difficulty in preparing the agreement appropriately and contextualizing the respective obligations. Let me give you an example. Sorry, I believe somebody is unmuted. A little bit of housekeeping. Please, everybody, I hope you don't mind, can you just mute yourselves? Thank you very much. We will get to a Q&A session closer to the end. So you understand the transaction. Is it the sale of shares? Is it a cession of the bare dominium? Is it the cession of a usus of the shares? Again, understanding what is required and what is intended is vital. What I'd like to do, especially when it comes to an old favorite of mine, BE transactions, is prepare a diagram. Trust me, these diagrams are a lifesaver. They help you to map out how the obligations will flow, who's liable for what is supposed to happen, and also it gives you a graphic understanding of how the obligations are to unfold, especially with respect to tax obligations. It is definitely very useful when it comes to tax obligations. So I highly recommend preparing a diagram. Also, something I've picked up is that, especially within the realm of commercial and corporate clients, they really appreciate diagrams. It helps them understand the transaction, helps them understand what it's going to look like before and afterwards. It also can be used as an interpretation tool should it be drawn out in litigation, and should the parole evidence rule need it be applicable. Now, when drafting individual clauses and also continual instructions, think of the 4 W's: who, what, when, and where. Who must perform, what must be performed, when must it be performed, and where. For instance, something as innocuous as the obligation to pay, believe it or not. The purchaser must pay. What must he do? He must pay. He must stipulate the amount. He must pay 10 Rand, for instance, a packet of chips. When must he pay? He must pay it on demand by the cashier. Where must it be paid? At the cashier. So that's just an example. And also this actually brings us back to the common law, where in the absence of an indication as to when something's payable, it's payable on demand, and it's also payable at the person who is to be paid. So the 4 W's are vital when structuring your obligations. And in fact, if correctly structured, there are potential tax advantages that you can build into the agreement. For instance, certain accruals and receipts, you can literally delay that so that your client can rather have it take place within a different year of assessment for tax purposes. Again, this is deliberate use of language, and it is deliberate use of who, what, when, and where. Now, something that I see quite often is the desired legal effect versus the desired legal outcome. I must be honest, when I was drawing that slide, I was a little bit tormented inside as to how to phrase that, because your client will come to you. He'll say he wants to put the house into his child's name. Now, you are instantly faced with, okay, is he talking about a sale, a donation, maybe even merely just a lease? So you must understand what the client wants. Does he want it to be given to the son? Is he aware of the tax implications? Is he aware that maybe there's a better way to go about doing these things? For instance, selling the house by way of installments. All of these considerations need to be brought in mind by a practitioner, and hence why I tend to say knowing a little bit about a lot actually helps greatly, because then you are aware that, wait, you can actually sell property in installments over 5 years instead of immediately in the traditional OTP, if you will. So bear that in mind, because the desired legal effect and the desired legal outcome are 2 different things. A section 42 transaction comes to mind, that it has a very, very specialized legal effect, even though a set of shares would have had the exact same desired outcome. So bear that in mind, guys. Always remember what your client wants and what you can actually offer to add value. Again, this speaks to almost earning the fee that you charge for your agreement. Now the law, again, the basic requirements, never forget them. never forget them. Again, if I see an agreement where a minor contracts, I'm going to have so much fun, but please do not do it. Now, possibility and certainty. Make sure you don't use overly vague terminology and language in your agreement, because an agreement that is vague can be declared void. We call it void for vagueness, and it's a particular favorite of mine. So please use clear language when drafting your agreements and your clauses. And now we also get the other additional requirements. These are usually self-imposed, other than those imposed by legislation. Ones imposed by legislation that come to mind, for instance, all sale agreements must be in writing and must be signed in so-called wet ink. Then you get self-imposed requirements or formalities, if you will. For instance, the notarial execution of a deed of amendment to a trust deed is something I've seen a few times. To some, this adds the perception of legality and proprietary of what has taken place. Also, it can reduce disputes. If these requirements are adhered to, they can eliminate disputes altogether. Think about exactly that, an amendment to a trust deed. If done by way of notary, the notary is attesting to something happening, or it could be a notarial deed, for lack of a better expression. It adds certainty to what has unfolded, and hence the ambit for dispute is narrowed, which is great. Again, you hear a lot of disputing of wills. Yes, having it notarially executed could reduce the ambit for disputes. In my opinion, it's a bit over the top, but it is definitely something that is possible. And yes, you might have noticed that I'm talking about wills in the context of contracts. Believe it or not, a will can be looked at as a sort of contract in the very untraditional sense, but nevertheless, when wills are interpreted, some rules of interpretation that are applicable to contracts are sometimes used to interpret wills. So bear that in mind. And again, desired legal effect versus desired legal outcome. Bear that in mind. It's very important, very relevant. I won't labor on it too much. Now, drafting and revisions, formats of agreements. By far and large, I've seen two formats that have emerged: templated agreements and bespoke agreements. Templated are the sort that you can, for instance, buy at P&A, fill in the blank spaces. Now, these are great. Some clients will always ask for a template that they can replicate. For instance, conditions of sale when your client sells goods or renders services. Fair enough. But bear in mind, these are the most dangerous, because if you make a minor mistake, those mistakes will be replicated. And worst case scenario, you'll have to litigate upon those very same mistakes. In other words, trying to enforce something that you know to be problematic to begin with. So bear that in mind. Templated agreements need to be scrutinized with the highest level of scrutiny. Make sure, otherwise you'll have minor mistakes that just creep in and tend to almost convey an impression that this was a rush document. There may be deeper problems. Often, that is something I look for. When I see that there are minor mistakes, I look for deeper problems, and I find them, and they can be exploited in the realm of litigation. However, these templated agreements do serve a very good function. For instance, in the realm of selling of immovable property, those agreements have almost become stock standard, barring minor changes here and there. But still be wary. Now, bespoke agreements. Now, that's agreements that often legal practitioners prepare. I'm always in favor of a bespoke agreement, because in my opinion, a templated agreement is one, usually not applicable for what client had in mind. A few years ago, there was actually a fraud that was being perpetrated. And what would happen is a gentleman would approach property owners who were in need and say, okay, you know what? I can lend you money, you just sign all these documents. And they were all templated agreements, and it turned out that they were sale agreements. They were literally selling their houses, and this resulted in copious amounts of litigation, and even to this day judgments are being issued to try and resolve that mess. So bear in mind, templated agreements can confuse people. Bespoke agreements are my favorite, of course. We draft them, we provide them to our clients. They're always bespoke. They always try and give effect to what client actually intends and wants, the desired outcome versus the desired legal effect again. So enough about that. I'm not going to labor on that too much. Sequence of clauses. Now we're speaking about the drafting conventions. I've seen various drafting conventions emerge over the years. There is no set rules, thank goodness. I prefer the approach where you put the most important clauses first, because let's be honest, most people tend to be lazy and they will stop reading at a particular point. So the most generic, most boilerplate clauses will always be at the end. Hence why I'm not in favor of the structure where the special clauses group is at the end of an agreement. In my opinion, this does nobody favors. It merely results in people paging through agreements like mad men, or mad ladies, if you will. But I do agree with grouping of clauses together. Again, place relevant clauses closer to each other so that it allows easier paging, and it almost facilitates what is happening. Again, keeping certain clauses apart might be a tactic used to avoid certain implications becoming very apparent, where, for instance, this agreement's being negotiated by between two parties by their respective legal teams. This is a tactic that I've often used to try and balance the agreements while the other party wanted it to be excessively in their favor. Again, something you should strive for is a balanced agreement. It's beneficial to all concerned, and the last thing you would want is the reputation that you draft agreements that take advantage of certain parties who might not know any better. So this is how I like to structure clauses, with parties, definitions and interpretation, nature of the agreement. Yes, in my agreements I literally say what is happening in this agreement. Again, this is trying to find a balance between form and structure. Well, form and substance, excuse me. Then I always have my performance agreement clauses, and then my obligation agreements. Now, there's a difference between the two. Performance is something in my mind that's active. Obligations is more something passive. This is just my preference. It's by no means required or even recommended. It's just the way I go about doing things. Yeah, and then again, I know I'm laboring this point, but the deliberate use of language is imperative. Again, the difference between may and shall is enormous. You may pay the person 10,000 Rand. Is very different from you shall pay the person 10,000 Rand. So bear this in mind. In agreements, the use of language is absolutely important. Sorry guys that I'm laboring that, but agreements that are poorly structured and use very poor language and use excessive use of the word may tend to be agreements that are the most litigated upon. So just bear that in mind. Again, the 4 W's, always relevant. Always bear them in mind when you're drafting anything, even settlement agreements. Something that I've also done of late is address the agreement to a particular audience. Now, if this agreement is going to be used for instance, lending of money to people who might not have a university education, I'll definitely cater for that, using simpler language, avoiding Latin. Please guys, avoid Latin. Make the agreement simple to understand. In fact, often I would draft the agreements as if it were almost a guide as to how to implement the transaction. Clients found this of incredible value for money, and it resulted in recurring business. So that's also something to bear in mind. Also, how the agreement looks is a calling card, it's a business card for further business. A scrappy little agreement that uses single line spacing, it's typed in a 10-point font using Comic Sans. I promise you it's going to look ridiculous. Client's going to think it's a joke, and that will affect your reputation as a legal practitioner. So bear that in mind. So the recommended approach, at least this is my approach. Keep your clauses practical. He shall pay. Please avoid the overly wordy clauses. He shall, by these presents, appear before and at. Don't complicate things. Keep it short, simple, to the point, and practical. A practical clause results in less litigation, and then your client will come back to you because all the transactions client has entered into have resulted in profit for client. Client's making money, client is happy. That is definitely something that you want to foster. Now, avoid clauses that are overly academic. Now, there is an exception. Specialized agreements and clauses will contain clauses that appear academic or overly complicated. For instance, where you're playing around with the bare dominium of property or usufructuary of property. Again, now we're using almost academic terminology. These terms have certain meanings within the legal field, and using it is a good idea because these terms are almost universally known. That's when I would suggest that you use academic terms or even Latin. I see here I make an example of a Section 42 agreement. Fair enough. I've already touched on use simple language. Avoid Latin. The only Latin that I sometimes use in a contract is pro non scripto and inter alia, and that is about it. Or void ab initio. That's about it. I try to avoid Latin as far as possible. In particularly when it comes to the Consumer Protection Act, it requires simple language. Also, it requires font that is legible and not of a font size that could result in it being concealed. Also, short clauses are preferred over longer clauses. When I started drafting, I once drafted a clause that it ran over 3 pages. Just one clause. Maintaining that clause going into the future became problematic. So shorter clauses tend to be a lot better, easier to implement, easier to maintain in your repository of templates and precedents. So bear that in mind. Also, long clauses tend to hide the most mistakes. I love finding these mistakes. When we're litigating on agreements, I open the agreement, look for the longest clause, look at it. I definitely find mistakes in those clauses. So that's just something to bear in mind. Also, possibly the greatest invention ever since the creation of the contract is track of changes in Microsoft Office. I love track of changes. It allows you to convey the changes that you've made. Clients feel a sense of value when they can actually see every word. It adds a lot of value. Clients can see the effort that you've undertaken in order to make the applicable changes. It just adds great value to your stock as an attorney or legal practitioner, be it in-house or practicing as a sole practitioner or even in a firm. Tracker changes is definitely a great feature. You can look on YouTube as to how to use it. It works well. People understand it. It makes people happy. Then, I spoke earlier about revisions. Something I used to do was using header and footers to indicate revisions. Draft 1.0 or execution version in the top right corner or the bottom left corner, as the case may be. It definitely helps. It avoids clients from accidentally signing a draft instead of the execution version, which it does happen still that they still sign the draft version even though they know not to. But nevertheless, at least you've taken steps to convey to them that they ought to not to. I always insert watermarks on draft documents. This is very important in my opinion, because when client signs a draft document and it is countersigned by the other party, it can arguably be enforced. So having the word draft, void if executed, or do not use is a great way to help convey to client to avoid signing that particular iteration, lest they suffer the consequences. And then guide revisions by having client focus on the effect of the clause rather than the manner in which the clause was phrased. Again, we're speaking about the legal effect here. Clients might want certain clauses to be to use particular language. I found this to be the case when it comes to indemnities. So guide them by explaining the effect and say that the language or the terminology used was used to give effect to the desired effect. Excuse my language there. I know that was rather labored, but again, our job is to guide clients and also guide the parties who are signing these agreements. And then we reach finalization and execution. Again, clearly mark it as such. Confirm that the client is satisfied. This is very important to me as a practitioner. I want to make sure my client is satisfied. Also, by client saying that they're satisfied with the agreement in its form, they are conveying to you that it adheres to the instructions, which is definitely something as a practitioner I want to hear and have on record. Execution. Bear in mind that attorneys are legally obligated to explain the agreement to a person who, for instance, an unrepresented party. Bear that in mind. So assisting with the execution is definitely a value add in my mind. We add value by doing it. We guide them through, because clients typically are uncertain of this. As intuitive as the agreement may appear, we forget that clients do not actually sign these instruments on a daily basis. So they are hesitant, unsure, and sometimes they're concerned about this and that. So assist them with that. Ensure the applicable formalities are attended to. I know I've mentioned that earlier, but as a notary, I can't say it often enough. I like retaining a copy of the executed agreement on file. So should the original be lost or some dispute arise, I have the executed version to refer to and advise client. If you possess the original document, mark it as original. I'm not saying write on it as original. You could potentially stamp it with an original stamp. That's perfectly fine. What I would sometimes do is I write in pencil original, and I'd safely store the agreement. Very important. Very, very important. As you're holding on to the original, you are liable for it and its safety until such time as the original is given to client. Often, I see. Sorry, somebody muted me. I apologize about that. So look after the original. If you don't want that duty, you can give it to client. Make sure you have client sign for receipt of the original agreement. Very important. In fact, I would strongly recommend that you do not give out the original unless they're prepared to sign for receipt, because inevitably client will say they do not have the original, that you still have the original, and you would not have that proof had they not signed. And that is the nutshell as to how I go about preparing agreements. Let me see if I can stop sharing. Now, with that in mind, please feel free to raise questions in the chat or unmute yourself. I'm more than welcome to have this be interactive as possible. And yes, I see there's been a request for the recordings and the slides. The recording will definitely be uploaded to YouTube. As for the slides, I'll see if I can convert it and upload it as well. Would anybody else have any other questions? Please feel free to raise them. Alexa, Ian, your thoughts?
Hi, I just want to find out. I joined a bit late. It's Bianca speaking. Where on YouTube can I find this recording?
Actually, in the advert that we posted, it's also got the link to the YouTube channel. I'll see if I can quickly post it in the chat box. Ian, you're more than welcome to take center stage while I find that link.
Thank you very much.
Hi everyone, not much to add, just a caveat on my side. If you are not versed in entering into contracts or drafting contracts, err on the side of caution and consult with colleagues who are well versed in the subject. It is well worth your reputation as well as your firm's reputation to guard against fatal errors in contracts. As Bruce correctly pointed out, your intention versus the consequence may be a simple mistake in a long clause or a short clause, as the case may be, which becomes missed or unintended. For this purpose, please always ensure that if you are drafting as a novice, have someone there to proofread your work. Thank you.
Good afternoon. I would also like to just add to that. When is a contract also terminated? It's important to know when you can terminate a contract, and that is when the performance becomes impossible or unlawful, and also when the other party breaches the contract. And usually cancellation happens in terms of breach or misrepresentation or duress, undue influence, or when it is commercial bribery. Also, the impossibility of a performance prevents the creation of a valid contract, and also it supervenes, lacking the supervening impossibility of performance. So when it is a material or reasonable mistake, the contract is definitely void. I would also like to just quickly mention that in terms of the High Court rules, the uniform rules of the High Court, in terms of Rule 18.6 and Rule 18.7, those are the two rules that apply with regards to contracts. So Rule 18 says that when you are drafting your pleadings and you deal with a contract, the contract must be written or oral, and when and where and by whom it was concluded. That's in terms of Rule 18.6. And also, if it is written, it must be attached and annexed to your pleadings. Rule 18.7 concludes that that if it's not written, then it is definitely implied term with regards to the contract. So that's what I would like to just quickly brief up. I'm sorry I missed the beginning a bit. I'm not sure if the requirements was mentioned in terms of the contract, but that is what I would like to add to the discussion today.
Thank you very much, Ian and Council. I couldn't agree more with both of you. If you're not well versed with agreements, err on the side of caution, have a colleague, have a quick squiz of the agreement. They will have a different view of the agreement. That's always beneficial. You can benefit from their perspectives. Remember, somebody's always got something to add that can benefit your contract in some way or another. For instance, counsel might say, listen, I've done a lot of litigation. People will fight over that. Make sure it's right.
That's true. It's very important to have it in writing, especially when you're drafting your pleadings. Make sure that you have all your annexures in place, whether it is in writing or whether it's implied. It can either be an agreement, whether if it's not in writing, of course. And that is Rule 18.6 and 7, which applies to pleadings with regards to contracts.
Thank you, Counsel. Yes. Remember, comply with those rules. Often, I've actually just read recently case law on an exception that was taken to a simple summons. I won't delve into that component, but the person raising the exception claimed that it was acceptable because the agreement wasn't attached. And the judge even remarked that, okay, I'm going to ignore the simple summons component again, but the judge remarked that, yes, to a combined summons, the agreement would have to be attached, because the combined summons, the particular claim in particular, are pleadings, so would need to be attached. The judge did say that also, were the agreement not attached to a simple summons, getting default judgment or even summary judgment would be very difficult. So bear that in mind, that sometimes you also got to think about these matters strategically. Counsel, your thoughts?
Absolutely agree with you there. Absolutely well done too. I just missed about the beginning, but it was a well presented session today. You covered most of the things that I was going to discuss in the beginning. I just had to add to the rules and determine in that regard.
Thank you, Counsel. I'll carry your words forever with me. So,
Hi, colleagues. Sorry, I've been raising my hand.
sorry, yes?
Yeah, so I want to know, because for me, I'm new to contracts, so I want to know, because I've been a personal injury attorney, but now obviously I'm getting a lot of instruction of contract, and I wanted to find out what books can you guys recommend. That obviously I do consult with counsels, with friends who are in that space of law, but I also want to know which books or sort of that can able to assist in sharpening my contract law skills. Thanks.
Well, from my experience is definitely your teacher here. Experience is definitely going to help you by far. It's good that you've got experience in different fields, especially personal injury. Then you can draw from that and apply it in your agreements. I can't recommend a particular source or book, since you didn't specify what sort of agreements you're getting in of late. But truth be told, my Bible for contracts is Christie, the law of contracts in South Africa.
Also, if I can add to that, there is a book called The Law of Contract. I don't currently have it with me right now, but I do have it. I'm not sure of the author. It's a blue book. It's a very thick book. That is a helpful book. Also, in terms of the rules of the court, Rule 18.6 and 7 applies to contracts, which is very important. And also LexisNexis for your cases is really, really a great help. If you can't, there's a law library that's currently available, which is free for many people, that you can also look into as well. And then one more thing, which I don't know if many of you have, it's a book called Marnavik. Marnavik is used by most advocates, and that book is so helpful when drafting pleadings and drafting you get all the different pleadings in that book, also with regards to the rules that applies to the pleadings that you're drafting, especially contracts.
Sorry,
Thank you so much.
You're most welcome to also just pop me a message if you want. I can get you the author's name of that book. I don't have it with me right now. I should get it. I'll try. I think I left the book at home though.
Sorry about that, guys. Thank you for your question.
I'll just drop my details in the chat.
Thank you, Yasmin. Thank you for that.
Okay, I think I found the title of the book that I would never leave home when it comes to contracts. There we go. But have a look at what other people are doing. Reading agreements is definitely beneficial. It helps you see what people are doing. Also remember that what I love about contracts is there's no rule as to the way they have to be, barring certain exceptions. So it allows you for a lot of freedom. Most of the time there's no right or wrong answer. There's just merely convention and how people would prefer to see it. So don't feel let down or constrained that you must make it look in a particular fashion. Cool. So any other questions? Sorry, I think I might be getting messages regarding the session. My apologies. But it appears that we don't have any further questions. Thank you all for joining. It's much appreciated. We really enjoy these sessions, so feel free to submit topics that you would like us to discuss, and always feel free to contact us should you need assistance. Thank you all.